Hi, how's everyone doing? This is attorney Moumita Rahman. I'm an immigration attorney here in New York City. You can call me at 212-248-7907 if you need a consultation on your case. And thank you for joining me today. I do a Monday coffee with Moumita every week when I can. It's a little bit late today, so I apologize for that. I've been pretty busy. But today I wanted to discuss with you what to do if you have a conditional green card and your marriage is falling apart. So when you apply for a green card through marriage, if your marriage is less than 2 years old at the time that you are approved for a green card, you will receive what's called a conditional green card. And it's called a conditional green card because the government only gives you 2 years on this green card, and before it expires, you have to apply to remove the conditions to convert that 2-year green card into a 10-year card. And one of the things that you have to do is prove that you entered your marriage in good faith, and that you've been living together, you're still married, and that everything is good. So as we know, we have a pretty high divorce rate in this country, and it's just difficult to be married. And by the time that a lot of couples have received their conditional green card, and in the 2 years after that, it may not work out. So what happens if, let's say, you have a 2-year conditional green card, and you have to apply to remove your conditions in 6 months, but you and your spouse are having some problems? So one, you would be eligible to request a waiver of the joint filing residency. So if you're still legally married to your spouse at the time that you have to apply to remove the conditions, your spouse has to apply with you. But you could ask for the government to waive your spouse having to sign off on that application on the basis of a few reasons. So one is if your marriage has ended. So you need to have a divorce certificate for that. The second is, if you're requesting a waiver based off of extreme cruelty or battery because you've been abused by your spouse. And another is, if you would suffer extreme hardship if this waiver is not given. So I'll discuss the two most common situations that I see in my practice and the clients that I get. So the first most common situation is a couple is still legally married to each other, but they're no longer living together, and now the spouse has to file to remove their condition. So what do you do? So the first thing that I always ask is, well, I understand that you and your wife or husband are no longer together and you're no longer living together, but are you still on good terms? Meaning, if you file this application, would your spouse sign off on this application and possibly appear at an interview with you, if you're requested to show up? If the answer is yes, I still vet everything very carefully. I make sure there's enough proof in the application to support that they entered into a good faith marriage. And I also disclose right away that they're no longer living together, because I never want my clients to be accused of misrepresenting the fact that they're not living in the same place. So as long as we disclose that the two people are living in separate places, but they are still legally married, thus that's why they're doing a joint filing, the application might be challenged, you might get called for an interview, but if the couple is still on good terms, there's not a reason why it can't be approved. Obviously, we have to prepare very well and make sure everything is done properly. But I've definitely had couples in the past where they were no longer living together and they were separated, but they still loved each other and they still wanted to support each other through this process. So that's one. But, as we know, divorces and separation can be quite contentious and full of a lot of emotion, and your spouse may not be willing to ever see you again, and they never want to talk to you, and they definitely don't want to sign another application to help you, and they don't want to appear at another interview in front of immigration. So when people come to me with that sort of a situation, what I say is, now what you have to do is you have to file for divorce. If you know that they're not going to help you with this, and there's no other waiver that we can request, for example, you were not abused and you were never hurt by your spouse, so we can't request a waiver for that, then what I say is you need to file for divorce, and we have to wait until you are very close to getting the divorce certificate and then file to remove your conditions. And this can be very stressful because in New York, especially, it takes at least 6 months, sometimes more, to get a divorce finalized. And by that time, you might already have an expired green card, and you definitely don't want to push that limit. Personally, I can understand that, but what I can tell you is that if you file your application to remove conditions, before it expires, and then you tell the government that you're going to request a waiver based on divorce, but you don't give them a divorce certificate, what will happen is that the government will issue a request for evidence for that divorce certificate, which you have to give within 87 days. And like I said, it normally takes at least 6 months to get a divorce done here in New York. Some people can do it for less time if they're filing in a different jurisdiction upstate, but that's generally how long it takes. So if you file without a divorce certificate, then you run the risk of having your application completely denied and then placing you in removal proceedings. So the best strategy in this is to, let your card expire, get the divorce done, then you file with the waiver for divorce. And it's actually okay, like you can miss this deadline on your card if you are requesting a waiver based on termination. The government is not going to reject your application. However, you won't have proof that you're in valid status for some time. So, it definitely makes people nervous. And what I would say is that if you know that your relationship is falling apart, start the divorce proceedings as early as you can so that you have enough time to get that divorce decree in your hands when you have to file to remove conditions. And yeah, so that's that. And then the next most common situation that I see is, unfortunately, if a spouse is being abused, and the U.S. citizen spouse is unwilling to file the application to remove conditions, or they're not, they're holding it over the person's head, or you just you've separated and you no longer want to live with them and you don't want to have anything to do with your spouse. So in this case, you can request a waiver for extreme cruelty and battery. And, the standard is you either need to have suffered physical violence at the hands of your spouse, or you need to have suffered extreme cruelty, the standard which is usually you have to show that there was a pattern of very controlling, abusive behavior, which was not physical, but when taken together as a whole, it counts as a pattern of violence. And for this, we can usually find many things that together are very, very abusive, including financial control, financial abuse, emotional abuse, manipulation, and general control, name calling, all these things. We tend to find everything together. So, so that's one way that you can request a waiver. So these are the most common scenarios that I see in my practice. This is what happens, this is what you can do if you have a conditional green card and you need to remove your conditions. If you're lucky enough to be in a relationship where your spouse is going to help you, then that would be great. But if not, then just please know that you do have options. It is definitely best to hire an attorney. If you have any questions or if you would like a consultation on your specific situation, please give me a call. My number is 212-248-7907, and we can set you up for a consultation. Thank you. If you have any questions or comments, please leave me a comment on this post. Otherwise, I will see you next week. This video is for informational purposes only and does not constitute legal advice. For proper legal advice on your case, please call us to set up a consultation.